to my channel, Botswana Thinking Law, where I bring you and the law closer. Today on this channel, we're going to be talking about court process. And because this is such a long topic, it is going to be divided into 3 parts. This video is part 1, where I will be dealing with actions. These are matters that are started by writ of summons. In part 2, I will be dealing with applications, and in part 3, I will be dealing with executions. Before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. I also wanted to let you know that the video also has timestamps. And if you're on a laptop or computer, if you're looking at the video, you'll see at the bottom of the video there's a broken line there. And every time you go to a certain portion in the broken line, you'll see that it's a specific topic. So you can use that to skip to different topics on the video. Or if you're also on your computer or laptop or on your phone, you can go to the description. And the way to get to the description when you're on your laptop or computer is to go to show more, scroll down from the socials, you'll see the time codes. If you're on your mobile, you just press the arrow button and it will show you the description. You also scroll down until you get to the time codes, and then you just press on the blue portion on the time codes and it will take you to that particular time and topic on the video. Now back to our video. An action is started by way of writ of summons, as previously explained. A person who starts a matter by action is called a plaintiff, and the person or people that are sued are called defendant or defendants. In the writ of summons, the plaintiff has to give their full names. They have to explain who they are. For example, they have to say they are a man or a woman, and they have to state whether or not they have capacity. And you would have noticed from my previous videos dealing with capacity, it is necessary because there are instances where a person does not have the right to sue. They also have to give the address, and this is the address where they, as the plaintiff, say they will receive all court process in relation to this matter. The defendant should also be described. The name should be there. They should also be said to be a man or a woman, whether they have capacity, and the address for the defendant. One may wonder why it is important to say whether this person is a man or a woman. And the reason why this is important is because previously in Botswana, a woman who was married did not have the ability to act by herself without the assistance of her husband, where she was married in community of property. That is no longer the situation, but you are still required to put that detail in your summons. Also in the summons, you have to explain why you say the court can hear this matter. And you will understand this if you watch my video on courts. It is because different courts have the power to hear different types of matters. In other words, if you're asking for someone to pay back money that they owe you, you can't take the matter to the industrial court, because the industrial court only deals with matters in relation to employment. Attached to the writ of summons is something called particulars of claim. In the particulars of claim, the plaintiff tells the story for what they are asking for from the court. If, carrying on with our example, the plaintiff says the defendant owes them 100 pula, then the plaintiff has to explain how it it came about that the defendant owes them 100 pula, and why they say the court should give them certain orders to recover that 100 pula. The plaintiff has to also, in the same particulars of claim, set out what they're asking for from the court. An example would be, I want the defendant to be ordered to pay me back my 100 pula, and I want interest in the amount of 10% per month or per annum, or I want costs for this matter. A summons, once it's prepared with the necessary documents, it has to be taken to the court, what is called filed. Once the summons is filed, the court will then give it a case number, will say the name of the judge and the court that is dealing with the matter. For example, it will say Francistown, Lobatse, or Gaborone if it is the High Court. Once the summons is issued, then it has to be served on the defendant. It has to be served on the defendant within 6 months of being issued. If 6 months passes without the summons being filed, then that summons expires. If a person manages to serve the defendant with the summons, then they have to file a document with the court called an affidavit of service, and in it they tell the court when they managed to serve the defendant and where and at what time. Once the defendant receives the writ of summons, in it they will note that they are given a certain time within which to file a document with the court called an appearance to defend. And this appearance to defend has to be filed and served within that period, which is usually either 14 or 21 days. The defendant in the appearance to defend will give reasons why they say the plaintiff should not be given what they're asking for from the court. Carrying on the example of the 100 pula being owed, the defendant could say, the plaintiff told me to pay this money back to his or her sister, and I paid the full 100 pula to that person appointed, and therefore I do not owe. If the defendant does not have a good reason for why they say the plaintiff should not be given what they're asking for, they should attempt to settle the matter with the plaintiff. In the appearance to defend, the defendant will also put in an address where they will receive any court documents or communications in relation to the matter. Once the appearance to defend has been filed with the court, a copy is then served on the plaintiff at the address that they chose. If either party has attorneys, then all the documents have to be served on the attorneys and not the parties directly. If the 14 or 21 days given expires without an appearance to defend being filed and served, then the plaintiff can apply for what is called default judgment and ask for a writ of execution to be given against the defendant's movable property where the issue is money. However, there are certain matters where default judgment cannot be applied to in this way. Instead, it has to be a matter being set down before the courts. I, however, deal with debt recovery in videos that will come later on in this channel. If the default judgment is granted and writ of execution issued, then the plaintiff can start the execution process, which I will be dealing with in part 3 when I talk about executions later in this channel. If an appearance to defend is filed and served within the 14 or 21 days given, then the plaintiff prepares a document called a declaration. In that document, the plaintiff sets out the full details of why they say they should be given by the court what they're asking for, and in it they also attach the necessary documents that will help the court to make a decision. An example of this is if it is a loan or a debt, then the plaintiff will attach the loan agreement. If the plaintiff does not believe that the defendant has a good case, or the appearance to defend does not indicate a good defense, then the plaintiff will also file what is called an application for summary judgment. In that application, they are saying the reasons given by the defendant for why I should not be given what I'm asking by the court are not good enough, and therefore, court, give me what I'm asking for. The declaration and application for summary judgment have to be filed and served within 14 days of the plaintiff receiving the appearance to defend. Once the declaration and application for summary judgment have been filed and served, then the defendant will file and serve what is called a plea, and they will answer the application for summary judgment. It is not every matter that is able to be dealt with by summary judgment. And usually matters relating to debt or eviction are the ones where you can apply for summary judgment. However, you have to contact your attorney or get the services of an attorney to understand fully this court process and what process requires this sort of application. In the plea, the defendant will also set out the story for why they say the plaintiff should not be given what they're asking for. In the example we had previously given, where the defendant claims that the plaintiff said, "Pay this money to my sister," the defendant will then attach documents to show that the plaintiff told him to pay the money to his sister, and to also show that yes, indeed, he did pay that money to the sister and therefore he does not owe. Once the defendant has filed and served this plea and opposition to summary judgment, which has to be done within 14 days of receiving the declaration and application for summary judgment, then the plaintiff can file what is called a replication. And the replication is filed in order for the plaintiff to deal with any issues raised by the defendant in the plea that are not covered in the plaintiff's declaration. The matter is then called for the first time before the court, what is called roll call. Roll call can come after the filing of the replication, or it can also come sometime between the filing of the writ of summons and the filing of the plea or declaration. At any point in time, the matter can be called for the first time before the court. At roll call, the parties or their representatives will then tell the court how far the matter is, and they will then, if an application for summary judgment has been made, ask for a date for that application to be heard by the court. If there's no application for summary judgment made, then the parties will ask for a date for what is called an initial case management meeting, ICMC, where the matter is set down for hearing of summary judgment. The parties have to file before that hearing what is called heads of argument. In heads of argument, they set out the law that supports their position. The plaintiff will say, I am supposed to get what I want because the law says this in this specific case. The defendant will also say, the plaintiff is not supposed to get what they want and give the cases that show why they're saying the plaintiff shouldn't be given what they want. The matter is argued. The judge makes a decision, and the decision could be that the application for summary judgment is dismissed, and if it is dismissed, then the matter is set down for ICMC or initial case management. If the summary judgment is granted, then the plaintiff, once they receive their order, asks the defendant to pay them, and if the defendant does not pay, using the example of the debt, then they can apply for the issuance of a writ of execution. Now, in dealing with ICMC or initial case management, the parties will meet, or their representatives will meet to agree on certain issues, and these issues are set out in the rules of the various courts, being Magistrates Court and High Court. They then prepare a report of all these things that they discussed and agreed on, and they file this report with the court. Now, it is very important to understand this process. And the reason why it is important to understand this process is because if you don't participate or take part, then your matter might proceed without you, and the judge might decide against you because of your lack of participation. Once the report has been filed, the parties then return to court on the date set where this report will be made an order of court, and the matter is set down for another case management called a final case management. The people are going to meet again, prepare another report. This report will be different from the report for an initial case management because in it they also deal with people that they are going to call as witnesses and how many of those people they are going to call. The things to be dealt with in the final case management meeting are also set out in the rules of court. Once the parties have prepared the final case management meeting report, it is also filed with the court. They then go back to court on an appointed date set by the court, and they have this final case management report made in order of court. They then ask the court for trial dates. If parties have looked at the requirements of the final case management report, there are various documents that have to be filed. And these documents include things like witness statement or discovery. Discovery being the documents that the party intends to use at trial. These documents have to be filed before the trial. Now, When a trial date has been set by the court, then the parties appear. They appear with their witnesses who will be called one at a time to come and give their evidence. The plaintiff, who is usually the first witness, will get into the witness box and be asked questions by their representative, who is an attorney, or they will give their story if they are not represented. Once they finish giving their story, then the defendant or defendant's representative then asks them questions. This is called cross-examination. After the cross-examination, the plaintiff can then be asked questions again by their representative to try and clear up some things that might have come up in cross-examination that they saw as problematic, or the plaintiff, if unrepresented, can give some address to the things that they said on cross-examination. However, in this process, which is called re-examination, the plaintiff cannot give evidence that they have not already given when they were in cross-examination or when they first started giving evidence. The witnesses are all called for the plaintiff, and once all the plaintiff's witnesses are finished, the plaintiff's case is closed and the defendant then opens their case. The defendant then gives evidence for why they say the plaintiff should not be given what they're asking for. Again, the process is similar to that of the plaintiff's witnesses, where the defendant gives their evidence for the first time. It is called examination in chief. After the examination in chief, there is the cross-examination by the plaintiff or plaintiff's attorney, and then re-examination by the defendant or the defendant's attorney. The defendant's witnesses are also called and they go through that same process. Once the trial is complete, then the court can ask the parties to prepare what is called submissions. And in the submissions, the parties summarize all the evidence given, and then they put out cases that they believe support their position and the cases that demonstrate that they are entitled to what they're asking for. In the case of the plaintiff, they will be asking if it's a debt for the defendant to be ordered to pay them. And in the case of the defendant, they will be asking for the plaintiff's matter to be dismissed. The judge will make a decision, and this decision could be to grant the order asked for by the plaintiff or to dismiss the matter as requested by the defendant. If the matter is dismissed, then the defendant, if awarded costs, can claim those costs from the plaintiff. However, if the plaintiff is successful and the order for payment of money is granted against the defendant could pay, but if the defendant does not pay, then the plaintiff can take the matter through the execution process, which will be dealt with in part 3, coming later on in this channel. And that is the entire congested court process in relation to actions. Remember, sometimes you could have a good case or a good defense for a case brought against you. And it is for that reason that it is important to engage the services of those who are knowledgeable in the law to advise you properly. Sometimes you can get a matter against you simply because you didn't keep the timelines that are supposed to be kept in relation to court documents. If you cannot afford the services of a lawyer, then we have a fantastic institution in Botswana called Legal Aid that assists people who cannot engage the services of a lawyer. But also, sometimes people assume that lawyer services are expensive. So it's usually best to call around lawyers to find out how much these lawyers charge and whether or not you can afford it. Because there is no substitution for the proper representation that you could get from a legal representative. That being said, I hope you managed to receive something that is more enlightening in relation to actions. Please, if you want to engage, you can leave a comment down below, like, share, and subscribe. And thank you for joining me in this video. Join me for part 2 coming up next week, where, as explained, I deal with applications. Thank you so much for joining me. Bye.